I'll address you when we get to the public comment period. I think most of those have to do with the MSDs, but if not, we'll take more at the end of the bandit sign presentation. If you didn't have a chance to submit your name for comments prior to yesterday's deadline, you're invited to use the public question and answer chat in the Microsoft Teams live link. I have staff monitoring that chat, and they can relay questions my way at that time. We have Mark Wooten from Public Works, who is going to start the first presentation. Take it away, Mark.
Thank you, Madam Chair. Good morning. My name is Mark Wooten, and I'm the Program Manager in Houston Public Works. I'm joined today by Mr. Wynn Colbert, Senior Assistant Attorney in the Legal Department. We are joined by Michelle Stayrook, representing Univar USA, Inc., and David Four, representing Houston Eureka Investments, Ltd. We are also joined by Amol Keskar, Ron Wood, and Colin Melson of Arcadis USA, Inc., and Tyler Arrington and Michael Marcon of In Control Technologies, the environmental consultant supporting today's MSD applications. Next slide. A municipal setting designation, or MSD, is a voluntary deed restriction that prohibits the use of impaired groundwater for potable purposes like drinking or cooking. It is a tool available to property owners to address public health concerns with groundwater. The use of this tool can allow for reinvestment and redevelopment of impaired properties. Next slide. This cross-section graphic on the screen depicts what an MSD is. You have a subject property with groundwater impairment. In this program, only shallow groundwater, which would not be used for drinking, is considered. Drinking water wells are typically much deeper than what is considered here. We require that the area where the contamination is or plume be fully defined on site, so we know where it is and that it is not growing and the source has been removed. Next slide. The MSD is a state program administered by the Texas Commission on Environmental Quality, or TCEQ, but it requires local support. Articles 13 of Chapter 47 of the Code of Ordinances provides the city's process to either support or not support a party's MSD application to the state. As part of that process, today we're holding this public hearing for 2 MSD applications. Next slide. The first application is to consider an MSD for a site located at 8425 Market Street. Next slide. Univar USA, Inc. is the applicant. The site is approximately 5.035 acres. Chem Central Corporation operated a chemical blending facility from the 1940s to 2005, when operations and equipment were decommissioned. The site remained vacant until 2007, when Univar Solutions acquired the property through its acquisition of Chem Central. In 2009, the site was leased to Santini Export Packaging, who presently occupies the property. Current operations include warehousing and international shipments of drilling equipment. The site is currently enrolled in the TCEQ Industrial Hazardous Waste Corrective Action Program number 36395. Next slide. The contamination at the site consists of 1,1,1-trichloroethene, 1,12-trichloroethane, 1,1-dichloroethene, 1,2-dichloroethane, 2-butanone, 2-hexanone, 4-methyl-2-pentanone, acetone, benzene, chlorobenzene, chloroform, cis-1,2-dichloroethene, methyl chloride, tetrachloroethene, toluene, trans-1,2-dichloroethene, trichloroethene, vinyl chloride, and total petroleum hydrocarbons. A licensed professional geologist has certified that the area of contamination is delineated as depicted in blue. It is stable and in most cases decreasing in concentration. Next slide. On September 25th, 2020, written notices in English and Spanish were mailed to property owners and registered civic groups within a half mile of the site, and to water well owners and operators within 5 miles of the site. Our department then hosted a public meeting on October 26, 2020 via Microsoft Teams. A copy of this application is online at the city's website, and a hard copy is available at the Tuttle Library. Next slide. The second application is to consider an MSD for a site located at 3509 Texas Street. Next slide. Houston Eureka Investments LTD is the applicant. The site is approximately 1.3234 acres. In the 1920s, a fuel station existed on the northeast corner of the property. In 1951, the property was developed with residential dwellings, and a wholesale chemical warehouse was located on the southwestern portion of the property. In 2019, the site was enrolled in the TCEQ Voluntary Cleanup Program, number 2988. Next slide. The contamination at the site consists of trichloroethene, Cis-1,2-dichloroethene, and vinyl chloride. A licensed professional geologist has certified that the area of contamination is delineated as depicted in red. It is stable and in most cases decreasing in concentration. Next slide. On December 31st, 2020, written notices in English and Spanish were mailed to property owners and registered civic groups within a half mile of the site, and to water well owners and operators within 5 miles of the site. Our department then hosted a public meeting on February 1st, 2021 via Microsoft Teams. A copy of this application is online at the city's website, and a hard copy is available at the Central Library. Based on the information supplied in these applications, input from various city departments, and input at the public meetings, my director has requested this public hearing. Depending upon the outcome of today's hearing, the Director of Public Works will request that council take action to adopt an ordinance to support these MSD applications. The ordinance will include all elements required by state law in Article 13 of Chapter 47 of the Code of Ordinances. The applicants are present today as required by the ordinance, and staff along with the applicant are available if you have any questions. Thank you.
Thank you, Mr. Wooten. As always, very thorough and good presentation of those two MSDs. We'll check the chat to see if there are any council member questions. I want to recognize that we have been joined by staff from Councilmember Cisneros' office as well. I'm not seeing any council member questions, so we can go directly to public comment on the MSDs. I will call your name. When I call your name, please unmute yourself, let us know your name, and if you represent any specific group or organization. Each speaker will have 3 minutes, and I will go in the order that we received. If you didn't have the chance to sign up before the deadline, leave your questions in the Microsoft Teams live chat to be read aloud, following the individuals who have signed up to speak. That's another way you can ask questions. All right, and we also have Mary Moreno is here representing Councilmember Tarsha Jackson. Welcome, Mary. All right, first we have Amy Den with Super Neighborhood 57.
Amy.
I can hear you, Amy. Is that you?
Yes, can you hear me?
Yes, go ahead.
Okay, thank you. This is Amy Den with Lone Star Legal Aid, and I represent Pleasantville Area Super Neighborhood 57. We have some concerns about the Univar MSD application that's before the committee today. First, the applicant has not expressed any plans for redevelopment in the property in a way that benefits the community or the city. And the general goal of the municipal setting designation process is to allow vacant or abandoned properties with groundwater contamination to be redeveloped. Here, they're seeking to escape the cost of cleanup for years of contaminating the groundwater in the area with multiple chemicals of concern, and we believe the city should require the application to meet all general site eligibility criteria established by the city on its website. There are specific concerns that have been expressed. We actually retained an expert on behalf of the community to review the application, and they have raised some very significant concerns regarding the failure to meet the criteria. First, failing to fully delineate the extent of the groundwater contamination plume to ensure that the contaminated groundwater at the site does not affect the underlying Chicot aquifer, which supplies drinking water to our region. Univar is maintaining that the clay soil prevents the vertical migration of affected groundwater, but it has not tested that assumption. And there are areas within 1.5 miles of the site where the Chicot aquifer is less than 50 feet deep, which increases concerns about contaminated groundwater migrating into the aquifer. Thus, the Univar cannot show that that plume is stable, which means there's no change or decreasing in concentration. Second, Univar has not properly determined or verified by calculations that the non-aqueous phase liquid or NAPL source is not present. If a NAPL source is present, which it appears to be based on the calculations done by our expert, it can contribute to ongoing contamination. Thus, Univar cannot show that the plume is stable or that the source of contamination has been removed. Next, trapped contaminants in the soil or another source of contamination are continuing to enter the groundwater. Thus, again, Univar cannot show that the plume is stable or that the source of contamination has been removed. And finally, the site in question operated over 70 years ago, back in the 1940s and 50s, and documentation of the contaminants of concern on site, which is an important part of the site history, is likely inadequate to establish what contaminants of concern are being at issue. Thus, we feel the site has not been thoroughly investigated with sufficient data. Additional investigations, such as collection of soil and groundwater sampling to be analyzed for additional contaminants like metals, pesticides, semi-volatiles, should be undertaken to rule out other contaminants at the site beyond the ones that Univar has analyzed for solvents and fuel components. And for these reasons, the Pleasantville area...
Amy, that's time. Can I get you to wrap up quickly?
I was on my last sentence.
Oh, good.
Sorry.
You almost got it.
For these reasons, Pleasantville Area Super Neighborhood 57 requested the city delay consideration of this application until these concerns are addressed fully. Thank you.
Thank you very much, Ms. Den. Thank you for your continued participation and looking out for and advocating for the neighborhoods you represent. You had a lot to unpack there. If you have a written version of those comments, I'd certainly like for you to get those from you. And we'll see what about the points that we can get addressed. Thank you very much for coming. Next, we will hear from Brit. Oh, I'd like to also announce that Councilmember Evan Shabazz is on the call. Thanks for being here, and also staff from Councilmember Robinson's. Okay, the next speaker is Bridget Murray. Bridget Murray, hit
Good
star
morning.
6. Oh, great. Yes, I can hear you. Go ahead.
Good morning. This is Bridget Murray. I want to thank all of the committee members for providing the additional time that we needed to review the application to respond. I'd like to also thank Mark Wooten for coordinating documents and the representatives of Univar for providing those documents. As a resident of Pleasantville, I am advocating on behalf of myself and the community that we would like to maximize our quality of life by reducing toxic exposures. Our concerns have already really been listed by Ms. Amy Den, and I really do appreciate the work of Lone Star Legal Aid. But just to identify those two concerns that I'd like to speak to, as far as the plume being stable and the plume being delineated. Until we have a clear determination of the depth of groundwater contamination, a decision in this matter appears to be premature to those of us who live in the community. Thank you.
Thank you very much, Ms. Murray. Next, we will hear from Michelle Stayrook. Ms. Stayrook with Univar, are you on the line? Do you wish to speak? Hit star 6. Okay, I will move to Amal Keskar with Univar. Amal Keskar, do you wish to speak? If you do, please hit star 6. Okay, I will go to George Rice. George Rice, If you wish to speak, please hit *6. Next, I have Ron Wood. Mr.
Hello?
Wood? Yes, I have somebody.
Hi. I'm sorry, this is George Rice. Can you hear me?
Yes, I can hear you. Thank you. I'm sorry. I
Yeah,
know it.
sorry.
No worries. No
Yeah,
worries. Go
I
ahead. You have-
apologize for the mix-up.
No
First
problem.
off, thank you for the opportunity to speak to you this morning. I'm George Rice. I'm a hydrologist working with community members who are concerned about the Univar site. I've reviewed Univar's MSD application and produced written comments based on my review. And there are a number of problems with the site. This morning, I'll just focus on the ones that I think are most important. First of all, Univar has not determined the depth of groundwater contamination. There are 14 monitor wells at the site between depths of about 25 and 40 feet, and contaminants have been found in all of them. This is important because the Chico Aquifer underlies the site. And although Univar has not determined the depth of the aquifer at the site, it could be much less than 100 feet. Also, Univar claims that clays will prevent the migration of contaminants down to the Chico Aquifer. But there's really no good reason to believe that this is the case. After all, the clays did not prevent the migration of contaminants from the surface down to where we find them today. Another problem is that there is probably NAPL at the site. A NAPL, that's NAPL, stands for non-aqueous phase liquid. NAPLs are a broad class of substances that include solvents that are more dense than water.
Did we lose him?
Things like TCE and PCE.
I think we lost him.
Hello?
Yeah, I'm trying.
Can you
to
hear?
connect.
Can you hear me now?
Madam Chair, I don't know what's going on.
Can you hear me?
Yes.
Okay. I don't. You said you lost me. I don't know at what point you lost me.
I lost you. Okay, I'm back. It looks like I'm back on. It appears I was dropped from the call for a bit, but you were just about to describe the acronym for NAPL, I think. I got the nod,
Okay.
and then I was off.
Great. Yeah. NAPL stands for non-aqueous phase liquid. And NAPLs are a broad class of substances, and they include solvents that are more dense than water, such as we have here at the site, TCE and others. So what happens is that when these solvents enter groundwater, they can sink downward through the aquifer until they encounter a zone of low permeability. And there they can pool, flow in different directions, and slowly dissolve into the groundwater that surrounds them. NAPLs are usually toxic, such as the ones we have here. They're usually very difficult to actually find at a site, and they may persist for many decades. Thus, if NAPLs are present at the site, they represent a long-term threat to the Chico Aquifer. So in conclusion, I think that Univar should be required to do at least three things. One, determine the depth of groundwater contamination at the site. Two, investigate the likely presence of NAPL at the site, and we have good evidence that NAPL exists there. And three, investigate any threat that site contaminants pose to the Chico Aquifer. Thank you for your attention.
Thank you, Mr. Rice, and sorry for the technical difficulties on my end.
No problem.
Again, I'll ask for either Michelle Stayrook, Amal Keskar, or
Good
Ron.
morning. This is Michelle Stayrook.
Yes, do you wish to speak, Ms.
This is
Stayrook?
Amol. Can you all hear me?
Do either of you wish to speak or both?
Amal, I'll quickly just add comment, if I may. I wanted to thank the Pleasantville community and their team for providing us comments, concerns on the application and our site. We have exchanged a Q&A and tried to address your concerns. We did receive some additional comments yesterday morning as well. So I just want to say that we're doing, taking the opportunity to address your comments, but if beyond this meeting we can follow up with those questions, we're happy to do so. But for the technical discussion, I will allow Amal Keskar from Arcadis to provide additional clarification.
Thank you, Ms. Stayrook. Amal Keskar?
Yes, thank you. Can you all hear me?
Yes, we can. Go ahead.
Okay, yeah, thank you very much. And thank you everyone for the opportunity here. We were all signed in through the Teams application and could not find a way to unmute ourselves. But going back to the comments and the discussion here, we appreciate the opportunity to provide our position. So just for the benefit of all the stakeholders here, Univar has done all the investigation work here at this particular project under the guidance of the TCEQ, Texas Risk Reduction Program framework. Going back to 2012, we have completed a comprehensive investigation of the project or the site to delineate the nature and extent of contamination in groundwater, and we have provided that information to the TCEQ in the form of an APAR, which is Affected Property Assessment Report, that was approved by the TCEQ. And secondly, after the approval of the APAR is when we proposed to apply for an MSD as a form of a response action for this particular site. So we believe that, Univar believes that we have met all the obligations and expectations of the SERP program. Going back to 2012, we have been continuing to do semi-annual groundwater monitoring at the site. We have a network of monitoring wells on-site as well as off-site, which demonstrates that the plume has been adequately delineated. As well as we have not found any NAPL, observed any non-aqueous phase liquid NAPL in any of these investigation phases or the monitoring phases that we have completed at the site. Secondly, in terms of the types of contaminants, when Univar decided to start the investigation program at the site, they looked at the historical information in the form of what type of chemicals were being used, formerly used at the site. That was all documented together. That's how we came up with a list of potential contaminants or constituents that we analyzed for or investigated for through an initial site assessment and then the follow-up investigation phases. In terms of the delineation, vertical delineation, the Chicot aquifer that is generally present below the site and in the general area is about 100 to 150 feet below grade. Based on our information that we have found through a comprehensive drinking water well survey that was previously submitted and to the TCEQ and approved by the TCEQ. We will continue to work with the stakeholders to address any of their concerns that they may still have, but we feel like we have met all the eligibility requirements for applying for an MSD, as well as we have completed all the obligations and expectations of the TCEQ turf
Thank
framework
you,
under
thank you,
this
Mr.
program.
Kaskar. That's time. Thank you very much for being here today.
Okay, thank you.
I'll call again Ron Wood. Mr. Wood, hit *6 to unmute. Okay, next, Tyler Arrington. This is on the Eureka Investments at MSD. Mr. Arrington, if you'd like to speak, please hit *6.
Yes, can you hear me?
Yes.
Excellent. Well, I'd like to first and foremost thank everybody for their time. I'm speaking on behalf of Houston Eureka Investments as their consultant, and at this point we have no comment.
All right, thank you for being here. David Four, also with Houston Eureka Investments. If you wish to speak, please hit *6. If not, we will move on. All right, thank you to everyone who appeared. Obviously, we looks like we have a little bit more work to do on the MSDs. So we will be working with Public Works and the community to make sure that all of the concerns are addressed to the best they can be addressed. So thank you all for participating. This is how we do it, and our process is made so much better by concerns. So thank you all, the applicants, and to the public speakers, and to Mr. Wooten for his presentation. And we'll take just a second and move on to what was going to be our first presentation, but now our presentation by Director Takasha Francis on from the Department of Neighborhoods on bandit signs. We all know about bandit signs, the signs that are in the public right-of-way and that aren't supposed to be there. I'd like to welcome Councilmember David Robinson, just joined us. Hopefully the press conference is wrapping up and we'll get some more participation. I know Vice Mayor Pro Tem Castex Tatum was very eager to get here. So speak slowly, Director Francis, and hopefully we will be joined by some additional council members. The floor is yours, Director. Oh, Castex Tatum is in. Okay, welcome, Vice Mayor Pro Tem Castex Tatum. Director Francis, the floor is yours. Okay, we're obviously having a bit of an issue getting her connected, so everybody bear with us for a moment and we'll make sure she has what she needs to get on. I can relate since I was just dropped from this meeting. So Director Francis, are you there? Okay, bear with us for a second, everybody. Thank you, everyone. We're about to begin the bandit sign presentation. We are awaiting Director Francis. Hopefully we're resolving any technical issues she might be having. So bear with us for a moment. Thank you.
Okay, good morning, everybody.
Good morning. I'm so excited to see you, hear you.
Okay, sorry about that. I was actually on live looking at it, and then I heard the Teams ringing, and I was trying to click out and get back in. So I apologize for that.
No worries, it happened to me too, so
Okay.
go ahead.
Good morning, everybody. Thank you, Councilmember Alcorn, for having me this morning, and greetings to all council members and guests on our presentation this morning. I'm always excited to speak on behalf of the Department of Neighborhoods, and this, of course, is an amazing presentation, and we're looking forward to it. So at this time, let's go ahead and get started. Thank you. Next slide. Now, today we're talking about bandit signs. A bandit sign is any sign which is illegally placed on public property or in the right-of-way. These signs are the lightweight, inexpensive advertising signs, usually made from paper, cardboard, or corrugated plastic. Some common types of signage include real estate, political signs, garage sale signs, we buy houses, we buy diabetic strips, all of those different signs that you see in the right-of-way. These are all bandit signs. Additional illegal areas include the stake-type signs, of course, that you'll see in the esplanades and the sidewalks and curbs. But then these also include the signs that you see on our utility poles and our traffic lights and our signal boxes. Next slide, please. Now, there are, before we get started, it's always good to know the legal ramifications, or at least the legal authority that sets the tone for the subject. First and foremost, on a state level, Chapter 393 of the Texas Transportation Code makes it unlawful for any individual or any entity to place and or commission the placement of a sign on the right-of-way of a public road that is not otherwise authorized by law. This particular part of the Transportation Code gives cities the right to create ordinances to provide specific permissions for their placement and, of course, to collect penalties. On a local level here, the City of Houston Municipal Code has sections 28-38 and 28-39. And then, finally, the Houston Sign Administration of the Houston Public Works Department regulates and permits all advertising signs within the City of Houston. The Houston Sign Code was originally developed in 1980, and it was revised in July of 2020. The Sign Code provides standards for the use, quality, construction, and location of these types of advertising signs throughout the city. It determines the height, the size, the lighting of those signs. And of course, when we talk about lighting, we're talking about commercial spaces and commercial properties or businesses that have specific lighting signs. So that's where the lighting comes in. So the sign code doesn't just deal with bandit signs, it deals with any type of advertising, including billboards. And that is known, of course, throughout the city, as well as the extraterritorial jurisdiction. I have something that's showing up on my screen over here that I'm trying to get rid of. So, okay, next slide. Now, the question becomes, who can impound bandit signs? And by impound, that means who can pick these signs up when they see them illegally placed in the right-of-way. Employees of the police department, planning and development department, solid waste department, Houston Public Works Department, the Department of Neighborhoods, and certain other city employees as designated by the Department of Neighborhoods director are authorized to impound any signs found on a public street, a public sidewalk, or a public alley and transport them for storage. So once these signs are actually picked up or impounded, they are put in storage with the Department of Neighborhoods, and those signs can be disposed of immediately, or they could be stored for up to 30 days. Once 30 days is up, they can be disposed of. And usually when we do store signs, there are certain types of signs that we may store if we get contacted by the owner and they say, hey, I want to come back and retrieve the signs, then the owner can contact us to come and pick those up from storage. In other instances, we do have the right by law to just pick them up and throw them away if they are illegally placed. So this is one of those nuisance infractions that does not require notice. Once it is illegally placed, it can be confiscated and disposed of. Next slide. Now, for bandit signs, what are the sign fines? The fines for bandit signs range between $300 to $500. Now, of course, the key to avoiding these fines is not placing these bandit signs on the city's right-of-way. And as we mentioned before, the bandit signs typically consist of any type of advertising on the stake signs in the public right-of-ways, which we kind of call litter on a stick, or those that are attached to our light poles and our traffic signs. Next slide, please. Now, what about political signage? This is an issue that comes up every election season. And one of the things that we wanted to talk about here is that there is no specific language to political signage in the City of Houston Municipal Code, okay? While there are general prohibitions and policies prohibiting signs in the right-of-ways, which is Section 28-38 and Section 28-39, historically the city will allow placement of political signs during election season. They'll allow those campaign signs on city properties that are used as polling places, as well as rights-of-way that are adjacent to those polling places. And as an administrative matter, the city's legal department will contact political candidates by letter outlining the city's requirements for political signage on city right-of-ways and property. This exception, however, for a placement of signs on city right-of-ways usually expires after the election. Next slide, please. Now, the letter is usually a three-page letter. It's a little bit long, but I just wanted to carve out a couple of specific rules, which I'm sure council members are already aware of. But these are just a couple of specific adjustments to our sign code as well as our statute. Campaign signs may not be placed adjacent to early voting locations prior to the beginning of early voting for both the election and the runoff election. So basically, the day early voting starts, you can start placing your campaign signs adjacent to those voting locations, but not any day prior to that. Campaign signs may be displayed only by attachment to the ground. So the only campaign signs are those with that have stick attachments or can be placed in the ground by metal attachments. However, there are no signs that are supposed to be attached to light poles, telephone fences, pylons, fire hydrants, trees, other signs, or any other fixtures or structures. Third, campaign signs must be placed in a manner that does not impair or impede in any way the use of parking lots, streets, roadways, driveways, sidewalks, walking paths, fire hydrants, or any other similar conveyance or structure by the motoring public, pedestrians, or city employees. Signs must not be placed in any part of any driveway or parking space at a polling location. Next slide, please. Now, of course, candidates are expected to inform their campaign staff and volunteers of these prohibitions and policies regarding political signage. Candidates will be held responsible for the actions of their supporters regarding the placement of signs. This is an issue that we do deal with every election season. And of course, I know as candidates, once you have people on your staff or volunteers that actually come out and put out your signage, we understand that candidates don't always know where their signage may appear, which is part of the reason why the letter is usually a notification from the city's legal department. And candidates are given, as is stated in the next button, if a city or candidate person is found out of compliance, you have 24 hours from the letter to go ahead and remove the sign. So that is the notice that is given in the letter. And of course, if that is not adhered to, a citation could issue and be prosecuted in municipal courts, or the city's legal department can file suit under state law to recover civil penalties to recoup the city's cost of removing the sign. Next slide, please. Now, this last slide talks about how to identify and report bandit signs, but also for some people who may or may not know, how to identify what the public right-of-way is. A lot of times when these notices are sent out, people don't have a full understanding of what the public right-of-way is. So this is just a nice graphic to explain for individuals when they see these signs and the location of these signs, what is considered the public right-of-way. So as you can see on the left, if there's a sidewalk, the right-of-way covers the area between the sidewalk and the curb. And as you can see over here, it shows the bandit signs are placed in what is considered the public right-of-way. What's more obviously, where is the esplanade or medians. That is the public right-of-way. So if there's an esplanade or a median, that's a public right-of-way. Signs cannot go there. That will be an illegal placement. And then finally, if there is no sidewalk, the right-of-way covers the area up to 10 feet from the curb. So the area up to 10 feet from the curb, if there is no sidewalk, is considered the public right-of-way. Additionally, as citizens, when you see these illegally placed signs, it is important for you to report these signs to 311. There is a mobile app, and this is, of course, the quickest and most efficient way for the Department of Neighborhoods to deal with the bandit signs complaints. Report them to 311. Give as much information as possible. We have a script that we give to our 311 operators who can take down the information, but try to give as much information as possible, including the street that it's on, any other landmarks that are nearby. So when our inspectors go out there to inspect, we'll be able to know exactly where you're talking about. Currently, at this time, we have 4 code enforcement officers that are dedicated specifically to enforcing bandit signs. So we have a first in, first out policy of addressing these bandit signs. We also, last year in 2020, had a total of about 1,619 calls from 311 regarding bandit signs. We wrote over 205 citations for bandit signs. And last year, we collected over 43,000 bandit signs. I think the exact number is 43,647 bandit signs were collected in 2020. So those are the statistics that we have. And this brings me to my next and final slide of the presentation. And now I am open for your public comment or your questions.
Thank you, Director. Great job. I mean, this is a bane of our existence, these signs. They keep coming. So I appreciate all the work that Dawn is doing to address this. We also have a couple people from the legal department on standby if there are questions that they might be able to address. I appreciate very much their being here. I'd like to start first with Vice Chair Amy Peck.
Thank you, Chair, and thank you, Director, for the presentation. Just a couple of questions for you. You talked about storing the signs for 30 days versus throwing them away. What's the criteria for storage versus throwing them away immediately?
Sure. It really depends, council member. So, when you see the cheaper types of signs, where you've got, we buy houses or things like that. In most instances, most litter on a stick that we kind of call it that are in the ground, we usually impound those and just kind of throw those away. But there are, like, for instance, some developers or, real estate persons who utilize more expensive signs. Those are usually the ones that we will impound just in case they want to, come back and retrieve those. And as I mentioned before, they do have the opportunity to retrieve them once they've paid the associate fines. So, when we see something where there's a little bit more of a financial investment, we will usually put those aside. And then, of course, as I mentioned before, sometimes we may get signs from other departments. Public Works is our partner with these obligations, and sometimes they'll call us with signs that they've picked up, and we'll just store them until we hear from the owner. But after that 30-day period, they're all disposed if they're not collected.
And how often are people actually picking up their signs, and how much does it cost for us to store them?
I don't have the schedule of fees right in front of me, Councilmember Peck, but we can get that over to you so that you can see the schedule of fees in terms of what a person would need to pay to collect their sign that's been impounded. But typically, depending upon the circumstances, if a person is invested enough in some of the, more expensive signs, they will contact us because they want to get those signs back. Now, one of the things that I did not mention in the presentation, is that, believe it or not, people, this is, can be a kind of dangerous for our code enforcement officers because, people have a misunderstanding sometimes of, not only just the placement of the signs, but of course, they get upset, when people come pulling up their signs because that's their financial investment. And so in some instances, our code enforcement officers have had situations where they have had to confront people while they're putting the signs down, or either after they pulled them up, people have confronted them about, taking their signs. And so it just kind of depends, but usually the code enforcement officer, depending on the circumstances or the situation, if you have a situation like that where a business owner comes out and they're just like, hey, I didn't realize I couldn't do that, we can impound those signs and we'll hold them until they're ready to pay the fees to pick them up.
Okay, and is there any kind of rule, that like if they are putting the signs out for a certain amount of time, if they keep doing this again and again, that we're not going to keep just impounding the signs and holding them, we're just throwing them away immediately after a certain amount of time of them doing this?
And I think I see where you're going with that, and if I'm not correct, then please correct me. But I think the path that you're going down is, why are we impounding signs that people can then turn around and put right back out? Is that kind of where you're going with that, or trying?
No, just if someone is doing this again and again, if it's the same company that we're constantly impounding their signs, is there some kind of rule that if you do it X number of times, we're not even going to impound it, we're just automatically throwing it away?
Right. Well, I don't think we don't have anything that's necessarily written in terms of, by this time you impound it a certain amount of times, or you just throw it away a certain amount of times. Overwhelmingly, we dispose of most of these signs. And there aren't a whole lot of bandit signs that necessarily reach the threshold of the more expensive kind. It's just kind of depending on the code enforcement officer's assessment. However, when it comes down to how we deal with what we call frequent flyers or repeat offenders, once we have actually investigated the situation, impounded the sign, and written a citation, then of course it goes to municipal courts, and then the prosecutor and the judge will take it from there to determine the fine that they are going to levy, how many days they're going to levy that fine, and what that cost is actually going to be. So we will pick them up as often as we see them, or just impound. That's kind of a case-by-case basis with the code enforcement officer as to whether or not they want to impound. But as a general practice, pretty much anything that we see that's in the ground, we pick it up and we throw it away.
Thank you, Director. Next question from Vice Mayor Pro Tem Martha Castex-Tatum.
Yes.
Thank you, Director Francis, for the presentation. I have a couple of questions. I'm definitely interested in the schedule of fees. And then I'd like to know what the schedule is for citations to be written to the repeat offenders. Are the Department of Neighborhood and inspectors writing citations to the repeat offenders, and the flow of that process, because that is what will lead us to the municipal courts and being able to actually go to trial, which I want to congratulate the legal team on their first big win on our bandit sign case on yesterday. And then I'd like to know if someone is placing bandit signs in a neighborhood and you live in the corner house and there are bandit signs in front of your home on the corner, a civilian that owns that house can pick those signs up, right?
That's tricky. So let me start there, and then I'll go back up to your first couple of questions. It is not recommended that civilians pick up those signs, simply because we have people that are deputized through the Department of Neighborhoods, Planning, the Police Department, and Public Works that are deputized to pick those signs up in the right of way. So if this is on that civilian's property, that of course would be a different situation. If it is in the right of way, then of course one of the persons that are deputized by the city of Houston would have to go and pick that up. It is not encouraged for citizens to pick up bandit signs because we have been given the statutory authority to do that. So if it's on that civilian's personal property, then that would be a different situation. But as long as it's in the city's right of way, then those deputies through the statute would have to be the ones to actually pick up and impound those signs. Regarding the schedule of fees, as I mentioned to Councilmember Peck, Vice Mayor Pro Tem, we will send that to you guys today because I don't have that right on hand, but the schedule of fees for collecting bandit signs, I'll be happy to send that to you all today. And as far as the fines for repeat offenders, how repeat offenders or frequent flyers are treated is pretty much outside of the hands of the Department of Neighborhoods, because we don't prosecute the cases. So that is with the legal department. Once we have written our citation, and as I mentioned, we wrote over, I think it was 205 citations last year. So once we write the citations, then our attorneys from legal prosecute those cases. And then, of course, judges determine, based on the recommendations of those prosecutors, what they want the fines to be, how much they want them to be, and whether or not they're going to assess them day by day. So that's out of our hands once we have already written the citation.
Would someone from legal like to, I'm sorry, Vice Mayor Pro Tem, if someone from legal that's on the call would like to address that question about the frequent offenders?
Can everyone hear me?
Yes, I think we have Ms. Winetta Cheney on the line. Thank you.
Hi, this is Winetta. So as far as the frequent offenders are concerned, yes, we do. When we prosecute these cases, that is something that we take into consideration, whether or not this person is a frequent offender. And if the person is interested in a plea bargain, we take that into consideration. And also, if we prosecute the case to trial, whether it be to a judge or a jury, then yes, we take that into consideration, and we will ask for, higher fines, of course, if the person is a frequent offender. And if the person is not a frequent offender, then, it really, in every case, really, it depends on the circumstances. I mean, you do have the occasion where, a person, this may be their first time doing it, and they may not have been completely clear on the law. And so, those are things that we take into consideration as well. And of course, we still prosecute those cases, depending on the situation. I mean, there's some times when, we feel that justice may require a different result, but we will certainly take the individual circumstances into consideration as far as the fines that we request in our prosecutions, if, assuming that person is found guilty after trial.
Thank you for that answer, but I want to go back to Director Francis. My question was, what determines if someone from the Department of Neighborhood will actually write the citation, and how can we get more citations written specifically for the predatory signs and for these repeat offenders who are blanketing neighborhoods and corners and stop signs and each night? You can ride anywhere in these communities on Fridays and Saturday nights. I think is when we get the onslaught of these predatory signs, and then you wake up on Saturday morning and you ride around your community. There's 150 signs in one specified area, saying they buy diabetic strips, or let us help you get a job making $18 million a week. These signs are visual spam. They're predatory. And I think you said there were 205 citations written, but we picked up 43,000 signs. Mm-hmm. How do we get more citations written so that people will understand we don't want this visual spam in our communities?
Sure, that's a great question, Vice Mayor Pro Tem. And the answer is we need more inspectors on the street. We currently have 4 code enforcement officers that are assigned to the bandit sign team. That is 4 code enforcement officers out of a total of 37 code enforcement officers for the entire city for all Chapter 10 infractions in the Department of Neighborhood. So one of the reasons that only 205 citations were written is because we only have 4 individuals responsible for that task alone. And so they cannot possibly write every citation that would probably need to be written. That's part of the reason why they try to do a combination of impounding, picking them up, making sure that we're able to get them off the street and write those citations as often as we can. But with 4 people, it's going to be reasonable to know that you will miss some people because we don't have enough people on the street to do that. So we try to do our best to write the citations and couple that with impounding the signs. But typically those 4 people travel throughout the city every week. We kind of divided up into 4 quadrants: southeast, southwest, northeast, northwest, to make sure that we're covering every district, which is one of the reasons why we can't do specific sweeps in a particular area. So more people on the ground to cover that issue, I definitely know would be helpful in terms of our ability to write more tickets.
I'd like for us to kind of dig deeper into this to see if we have, because several of our districts have hot teams and have people on the ground that are picking these signs up, if we can work together to get more citations written. Because I do think the only way that people will stop blanketing our communities with these signs is if we, if they have to pay these fines, because clearly calling them and asking them not to do it, doesn't work as well as if they have to go to court and pay a larger fine. So thank you for the presentation, and look forward to working with your team and hopefully getting some more people out there to be able to write these citations to keep our communities clean.
Thank you so much, and I'm very open to that as an opportunity.
Thank you, Vice Mayor Pro Tem, and thank you, Director. Another question from Vice Chair Amy Peck.
Yes.
Thank you, Chair. Director, just one final question. Has there been any thought to allowing citizens to take a class so that they can issue citations for this kind of thing, similar to what the city does for like handicap parking citations, that kind of thing? And I think the county, at least they used to have some kind of program like this. I'm not sure if they still do or not.
Yes, actually, Councilmember Peck, I'm glad you brought that up. We've actually been talking about that going back, I think at one point in time, when this code enforcement bandit signs was under Public Works, we did have a partnership with the county. And I think it was sign ambassadors or something like that, where they did have a community function. I'm not sure why that program was discontinued, but I'm certainly open to deputizing citizens to assist. Now, one of the things that we do have to be careful about, of course, is making sure that we have tied up all of our legal ends to make sure that there is no, verifiable liability, which I think should be able to be taken care of with waivers from our volunteers. But I am absolutely open to that, and I love the idea. So we'll definitely, let's talk more about that and see what we can do.
Great, thank you.
Thank you, Vice Chair. And I will say, Director Francis, when we were doing some research on this subject in other cities, we saw on San Antonio's website, it says citizens may remove unpermitted bandit signs at their own risk. And then they say, think safety first. I mean, I confess, I've removed some signs. If I need to go get deputized, sign me up. I'll get deputized. But I do think there would be a great advantage for these hot teams, for citizens, for, people that, if they're safely able to get out of the car and pick up a sign, or if they're on a walk, I mean, that's going to help too. That's good. That's going to help greatly. Councilmember David Robinson has a question.
All right, wonderful. Good morning.
Good morning. Thank you, Chair and Director. Thank you for your presentation. I've got a question picking up on what the Vice Mayor Pro Tem said. With the 4 inspectors you have, Director, by my math, that's about 1 every 135 square miles. That seems grossly inadequate. So I don't think you're going to disagree with that statement, but it does make me wonder, along with my colleagues, as you've heard, about the deputization process and what we can do. Are there other ways to approach this, like, say, the TERSs or the management districts, other taxing entities that have, again, some way where they're already out there with graffiti abatement teams and some of those that are looking at clean programs throughout the city, where we could add this, deputize them, and throw them in the back of a pickup truck?
Something, Councilmember Robinson, I'm actually open at this point. We're at a point where anything that we have not tried, I'm open to looking at, as long as it is going to be safe for citizens as well as the city. And so these are great suggestions that I'm writing down, and I'd love to continue those conversations to see how we might be able to do that.
Right. The other thing that's been evident in the chat and the Q&A is that the Super Neighborhood Alliance is picking up on that, which is lovely. If we could do more of that, whatever we can do to encourage it, and maybe there's a presentation that you can give before too long for that.
Okay, sounds good. Sounds good. And actually, what I'll do here, based on these recommendations, Ms. Cheney, I think, is still on the line. So we'll get together after this presentation and let's kind of flesh out what we might be able to do as far as the hot teams are concerned. I certainly do like that opportunity as well. So let me speak with Ms. Cheney and legal to make sure that we've dotted all of our legal I's and crossed all of our T's and see what we might be able to do to expand being able to deputize more people.
I'm fully available to you.
Thank you, Council.
Thank you. And again, congratulations to legal. Stephen Beard is on the call. He did win a recent suit on bandit signs. So props to legal. On the political sign issue, City Attorney Ron Lewis in March 2018 put out a memo kind of defining some of the rules that you listed here. But one of his bullet points on that memo said the number of campaign signs used at each location by each candidate must be reasonable. Have we ever defined reasonable? Has there ever been any work on this? Legal could answer too. When I saw that, when we were researching this committee meeting, I thought, I just wondered if that's ever been defined.
Actually, Councilmember Alcorn, I'm going to defer to legal on that because these are their specific rules. So I'm not sure what's considered reasonable. I can say for our department, we've never received a call or a complaint around someone putting up an unreasonable number of signage thus far. So I'll defer to legal on that.
Okay. And go ahead, Ms. Cheney, if you have an answer.
Well, I don't have a definitive answer, but I would imagine, since we haven't really had that particular issue come up, I would imagine that would be considered on a case-by-case basis, depending on the location of the signs and just the number based on that location.
Got it. Okay. Thank you. Looking in the queue for any other council member questions? I know we did have some live Q&A question about, hold on, just are fines for bandit signs ever imposed? Yes, I think we have answered that. They are imposed. What's the maximum? The maximum is $500. Is that determined by the state, or is that our maximum?
No, that is determined by the state. And as a matter of fact, I believe that State Senator Boris Miles is presenting legislation, which we have already agreed to and support, to raise that maximum, I believe, to $10,000 in this legislative session. But those fines are set by the state.
Okay, and it's a fine for each violation. It's each sign, right?
It could be for each sign, and of course for each day that it's actually out if it hadn't been removed. So that will vary depending on whether or not it's been impounded or how long it's been out there.
If I may present a point of clarification. So we have two zones here. We have the criminal zone and the civil zone. And so currently the maximum fine or the maximum fine or civil penalty is $1,000 per sign under the Government Code 393.007. And that is the subject of the bill by Senator Miles that is trying to raise that to $10,000 per sign, per violation. On the criminal side, each violation has a maximum of $500 per violation. And that is the total range that can be considered. Now, of course, that is the fine in and of itself. There are court costs that are going to be associated with that. But that is set by state law because it's considered a Class C misdemeanor, and it does not, and it's within our jurisdiction. Even though it's a city ordinance, it's a Class C misdemeanor within our jurisdiction. But because we don't have a clear nexus to health and public health and sanitation, we do have to keep that cap at $500.
Thank you for the clarification, Council.
Thank you very much, Ms. Cheney. That does help. I'd also just like to note in the live Q&A, there's interest, Director Francis, in super neighborhoods getting involved in helping spread the word about bandit signs. We'll make sure they get our list of super neighborhoods gets this presentation. It'll be online on the RNA website, and also, I mean, I think they're willing to help. So anything we can do to expand the number of people that can pick up these signs, I'd be all about that. Okay, seeing no other questions from council members, I really appreciate everybody's participation today. Last chance for questions. Okay, that concludes our meeting. Our next RNA meeting will be March 9th, 2021 at 10 a.m. Thanks for everybody for your participation. Great presentations. Oh wait, there's one last question.
Okay.
In the chat. My apologies. Hold on.
Sure.
Just when you thought you were out of here.
No, it's okay.
Okay, what would the difference between a bandit sign and political signs be? Because I'm worried this would affect small parties. Obviously not a whole bunch of signs like no tomorrow, but something reasonable. I'm not sure exactly. I think it was said earlier that we don't define political signs in our, those are a state regulated thing. We don't really define them in our code, right? We don't differentiate between bandit signs and political signs in our code. Is that correct, Director?
Well, just to further clarify, Councilmember Alcorn, a political sign is illegally placed if it is outside of the scope and time that the city allows for it to be there.
Right, okay.
So as long as the city, if it's during election season and it falls within the administrative restrictions that the city puts in place, then that political signage can be in the right of ways during election season. Outside of that, then it is illegal, and it would constitute a bandit sign at that time.
Okay.
Or illegally placed.
Great. Thank you for that clarification.
You're welcome.
All right. Thanks, everybody. This meeting is adjourned at 11:09. Thank you.
Thank you so much.